wise.
Welcome to FCPA Flash, the official podcast of FCPA Professor and moderated by Professor Mike Koehler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by the Red Flag Group. The Red Flag Group manages your integrity and risk profile, turning compliance into a competitive advantage. The Red Flag Group assists companies in developing and maintaining efficient and effective corporate governance and compliance programs and has a proven track record in providing integrity due diligence investigations in 194 countries.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Koehler, and I invite you to my next FCPA Institute in Nashville on May 4th through the 5th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page.
Welcome to FCPA Flash. This is Professor Mike Koehler. In this episode, I'm pleased to be joined by Karen Popp, a partner at Sidley Austin and team leader of the firm's white-collar, government litigation, and investigations practice group. Karen has an active FCPA practice informed by a wealth of government and private sector experience, including service as a federal prosecutor in New York, a lawyer in the Office of Legal Counsel at the U.S. Department of Justice, and Associate White House Counsel to President Clinton. Thanks for joining us today, Karen.
Thanks for having me.
2016 was obviously a very active year in terms of FCPA enforcement, indeed historic on a number of levels in terms of the number of enforcement actions and the overall settlement amounts. And it was also an interesting year from a policy standpoint in terms of DOJ and SEC policy developments. And in this episode, Karen is going to provide her thoughts on some of the top developments from 2016. So Karen, what's at the top of your list for some of the key trends or developments we've seen in this space over the last year or so?
Well, I definitely agree that this was one of the most significant years in FCPA enforcement. We saw huge settlement numbers. We also saw probably what's at the top of my list, which is reflected in some of these resolutions, is the collaboration that we've seen amongst various governments with our government in the enforcement space. It's something that we have heard the Department of Justice for a number of years be talking about, and it spans both the Bush as well as Obama administrations, the efforts that's gone into that, and certainly we see this year, or 2016 that is, a number of cases where the collaboration is reflected. Leslie Caldwell, the chief of the criminal division that just recently stepped down, has been very vocal about the efforts, and the other sort of a segue to another thing that we saw this year is continued increase in resources at the Department of Justice. We saw a 50% increase in prosecutors, 10 more prosecutors added, as well as additional FBI resources, and I think that has probably contributed to the efforts to collaborate more with other countries.
Yeah, and just for listeners' benefits, we saw several enforcement actions in 2016 that involved not just a U.S. component, but a foreign law enforcement component as well, notably the Brascom and Odebrecht enforcement action, the Vimpelcom enforcement action, the Embraer enforcement action, all involved a U.S. component as well as foreign components as well. And even if there wasn't actually an enforcement action per se brought by foreign law enforcement, we do see with increasing frequency, for instance, in DOJ and SEC press releases, a public acknowledgement of some of the assistance provided by foreign law enforcement agencies. How does that relate to some of the things that you do with your clients and some of the things your clients are thinking about, and perhaps contrast that with maybe 10 years ago, for instance, where I'm guessing most of your clients were just kind of uniquely focused on FCPA enforcement by the DOJ or SEC?
Well, certainly what we've seen in the government's conversations and pronouncements about collaborating with other countries, and now we see it in black and white. It's no longer the case that the U.S. is the only enforcer in town. And this is something that, given that corporate America is made up largely of multinational companies now, companies that are doing business throughout the world, companies can't just be concerned about U.S. enforcement. They've also have to be concerned about the local enforcement authorities in those countries where they operate. I mean, what we've seen in these cases in 2016, literally dozens of other countries have been identified as collaborating in the enforcement of their anti-corruption laws. And in fact, when you look at the sanctions that have been put in place as a result of these cases worldwide, around $6 billion, not even half, it's only about 2.5 of that are U.S. sanctions. The rest are sanctions from other countries. So companies need to be focused on the fact that not only do they have to worry about the U.S. government, but they also need to be concerned about their local governments in the countries where they operate.
Yeah, it's certainly an issue that as the world becomes seemingly smaller each and every year, is something that companies and counsel and compliance professionals need to have on their radar screen for sure. What else is on your list in terms of top developments from the past year or perhaps looking forward?
Well, I think, speaking of compliance, I think that, compliance is still a top priority of the government. I think that we've seen the Department of Justice and the SEC being extremely focused on compliance, and frankly, to your earlier question, how does a lawyer in this space counsel their clients and their operations worldwide? One of the things that you definitely want to do is to have in place very robust compliance programs. And what we've seen the Department of Justice do in bringing in a compliance expert to assist the fraud section over at DOJ, which of course includes the FCPA unit, is to have someone who will evaluate the compliance programs of those companies that are before the fraud unit, the FCPA unit. And what this means is that the government has expressed, by putting expertise in the room, the need for companies to have programs that they can truly evaluate from across the conference room table in these meetings. A lot of times when you are before the Department of Justice and you're explaining your program, your remediation efforts, etc., you may well be before someone in DOJ that's never worked in private practice or never worked in a company to see what a compliance program is all about in terms of how to build it, how to operate it. And so what the Department of Justice did in bringing in someone that has been in 3 compliance departments as well as a former prosecutor, she has that expertise to evaluate your program. and it's my understanding, she was brought in under a one-year contract, and it's my understanding that contract has been extended, and so, I think that compliance has been a very important issue in 2016 for the Department of Justice, and I don't see that going away. In fact, I think that it's even possible that compliance could be as big, if not bigger, of an issue in the new administration. I know that there's been efforts in the past to have compliance to be a more of an affirmative defense when a company comes under investigation, and it's certainly something that we've seen play out from a policy perspective in the FCPA pilot program, where remediation could in fact be one of the bases to receive a deferred prosecution agreement or a non-prosecution agreement, and we may see more of that even outside of the pilot program, assuming it were to continue. That companies that have effective compliance programs may well get more benefit in the resolution of the case.
And for listeners' benefit, the individual you were referring to was Hu Chen, who, as you mentioned, was brought on as the DOJ's so-called compliance counsel. And I was going to ask you, but you already answered the issue of whether her position is going to be extended, and based upon your information, it sounds like it will. Do you sometimes view the ever-increasing expectations of the government when it comes to FCPA compliance as always a net positive, or do you sometimes perhaps get pushbacks from corporate clients saying, well, now we got to do this, now we got to do this? What's the statutory basis for doing this, other than, of course, the FCPA merely says a company has to have effective internal controls in place without really statutorily defining what those internal controls are. Other than that, they need to be reasonable. Could you perhaps speak to these ever-escalating increased expectations in this space, and how companies in good faith are supposed to act consistent with them?
So, compliance is a very, the history of compliance is an interesting topic when you look over the last decades of how it has evolved, and the uses of a compliance program in the enforcement space. And there's been certain milestones in the compliance enforcement area, and certainly the FCPA is one of those milestones. But even before that, you've got Sarbanes-Oxley. That was another major milestone. I think that, at this point here in 2017, companies have now known for basically, 20 plus years, because I think it was in 91 that compliance came in, we first saw it in the sentencing guidelines. And then with the U.S. Attorney Manual, which started out initially with the Eric Holder memo, and then the Thompson memo, and eventually to the Phillip memo, the factors on prosecuting a company, one of which is an effective compliance program. I think over time, companies, certainly publicly traded companies, know that they now need to have an effective compliance program in place. And so there is a level of maturity that we see today that just wasn't there 20, 30 years ago. I think that if companies are going to spend all that time and money to put into place programs, and it's hard to know whether your program is effective or not, because it's, to me, compliance is more of an art than a science. That if a company is expected to have a robust, effective compliance program, and you're going to put all this time and money into building that program, the government needs to be more, give more guidance on what they expect to see, and also be more tolerant of the difficulty it is to administer compliance programs, especially around the world. And one of the reasons why I like the idea of having someone like a Wei Chen in as an expert on compliance is that there has to be a practical side to evaluating a program. It's my understanding that there has been more of that practical approach to assessing programs. And also, we've seen, the guidance coming out of the 2012 FCPA guidance, and the government has been, especially the DOJ under Leslie Caldwell, has tried to be a lot more transparent in their resolutions and what went into their decision making, and certainly the Department of Justice has been, as well as the SEC, has tried to be very noisy in their settlement documents as to what they expect in compliance programs. And I think this has been very helpful to corporate America in building what they understand is an effective program in their climate. What I want to see is that the government continue to give companies the credit where credit is due. And I am hopeful that will continue and may even continue more under the next administration.
Time will. Yeah.
No, go ahead.
No, time will definitely tell, and you're absolutely right. You would look at some of the resolution documents in this space in the year 2000 compared to 2008 compared to 2016, and the compliance expectations that are normally set forth in the so-called exhibits or attachment C to the resolution documents has really changed over time. And it's interesting though that the FCPA, the actual statute, hasn't changed one word, over the last 20 years or so, and it's almost as if these new compliance expectations are based simply on people at the DOJ and the SEC saying, well, this is what we think you ought to do, not necessarily this is what the FCPA specifically requires you to do, or not specifically what a court has said you have to do. And when it comes to guidance, you mentioned the 2012 FCPA guidance. Obviously, the real people who drafted that guidance are obviously no longer at the DOJ or the SEC in large part. Even the pilot program that you mentioned, those people are either not there today or will be soon exiting the Department of Justice. So guidance obviously is good, but you also mentioned the fact that we'd like to see a little bit more transparency over these points.
Yeah, and I think that the knowing what the government expects and having a government that expects reality, that is practical in what they expect, are two very important things. And what I have seen is an evolving aspect to that in the compliance space. I think there's a lot of work to be done yet. I think that the government needs to be more understanding, more tolerant of how difficult it can be to administer global programs. I think that companies deserve to have credit when they are working very hard to implement an effective compliance program. But I've also seen the government give them that credit, sometimes, not all the time. And I think that having someone like a compliance expert who has been in the real world as well as being a prosecutor, I think is very helpful in that regard. And also, it shows, the priorities that the department has, which I think are very good priorities because companies have known now for many, many years that they need to have effective compliance programs in place, not just because of the FCPA, but and the question is, are they going to get the credit where credit's due? And should that be a basis for a declination under certain circumstances, and I believe that it should be.
And, the difficulty in actually empirically assessing this is, to state the obvious, we know what we know and we don't know what we don't know. So just because the DOJ or the SEC says we credited this company with a so-called declination, or we credited this company with a reduction under the sentencing guideline fine ranges, we hear that, we read that, but to state the obvious, we don't know what would have happened if there wasn't a voluntary disclosure. So it's kind of difficult to really pinpoint down some of these credits, and that's been an issue that has long been talked about by the FCPA bar for probably close to over a decade. Now, you mentioned that the pilot program, for listeners' benefit, the pilot program was launched by the DOJ in April 2016. It was articulated as a one-year pilot program. Here we are in the waning days of that pilot program, at least as first unveiled. Do you think it might be extended?
So, it is hard to say, given that there's a new administration coming in. I think that it's my prediction that folks at the department believe that it's been a successful program. I actually commend the department for having such a program in the sense that there's been an effort through that program to provide some transparency into the benefits of voluntary disclosure, and I think there's been 5 declinations to come out of that program, and it was adopted in April of 2016. So by time the 1-year mark is up, I'm sure how many total declinations there'll be.
Yeah, just to be clear on that point, those 5 declinations you mentioned weren't exactly pursuant to the pilot program, but rather consistent with the pilot program, in the sense that all of those actions were on the DOJ's radar screen before April 2016. And at least to my knowledge, there's yet been what I'll call a pure pilot program case. In other words, a matter voluntarily disclosed after 2016 that has now been resolved, which on one level is not exactly surprising because of the long time frame it takes to resolve FCPA enforcement actions.
Yeah, I mean, you're right that it is hard to know what cases are in the works that came in during the pilot program period that will get resolved as part of the pilot program, even perhaps beyond the deadline of the program, if it were to expire, because it can take years to resolve an FCPA program. Now, of course, one of the objectives in the program was to, in fact, resolve cases more quickly, which is something that we all should desire, that the government get cases resolved quicker than it sometimes takes. But I think that the idea of, which is obviously one of the ideas behind the program, is to entice companies to come in, disclose, cooperate with the government, remediate, and you can get possibly a declination, but certainly 50% off your penalty, your fine, is something that the government should be trying to do for those companies who want to go in and disclose. Leslie Caldwell has said now a number of times, one of the reasons behind the program is that she believes that there are a lot of companies out there that just do not come in and disclose their issues. And she and the government are wanting, under the pilot program, to entice companies to come in. I think that the jury is still out because, for the reasons we've just said, there hasn't been enough time to see really how successful the program will have been. But certainly I commend the government for the efforts in trying to provide transparency to corporate America so that they know the potential benefits if they were to decide to disclose their issues.
Yeah, one of the stated goals of the pilot program, as articulated in the actual document and as articulated by Ms. Caldwell in public speeches, was to entice companies to voluntarily disclose so that the DOJ could bring those individual enforcement actions that the DOJ recognizes achieve maximum deterrence. One of the interesting points here, and I've written about this, is even though there's not perhaps been a pure FCPA pilot program action, in the 5 enforcement actions that the DOJ has self-selected as being resolved consistent with the pilot program, none of those actions, of course, have involved any related individual prosecution. So it's sort of interesting to measure the pilot program against one of the stated goals. What else is on your radar screen, perhaps, as FCPA enforcement transitions from the leaders at the DOJ perhaps last week or a few weeks ago compared to what we may see in the future? How would you look back at the DOJ's enforcement of the FCPA over the last few years?
Well, let me sort of start on the one point you made about enforcement against individuals, and obviously, the Yates memo, although it didn't come out in 2016, it came out at the end of 2015. We did have 2016 to look at whether that memo did result in an uptick. I think that prosecution of individuals, I think that too is too soon to tell. Whether you're looking at it from the perspective of the Yates memo or even looking at it from the perspective of the FCPA pilot program that you just mentioned, because that too can take a long time, and so we just don't yet know. I do think, though, I think one of the 2016 highlights, especially with it being the last year of this administration and the last year certainly of Leslie Caldwell's tenure as chief of the criminal division, is the effort by the Department of Justice to bring bigger, higher impact cases, which they announced, or at least I started hearing them say it in full force in 2015. I think that their efforts in going after that, we may be seeing the fruits, and that is something that Leslie Caldwell indicated, was a major priority of hers, and we certainly have seen, major cases. I think of the, several of these cases. I think now 3 or 4 of the cases that got resolved in 2016 are now going to be in the top 10 largest FCPA cases ever, and that's that is very significant. And of course, we've already mentioned that some of those have multiple other countries involved. So I think that this sort of the end of this era with the Obama administration coming to an end, the Leslie Caldwell tenure coming to an end, we've seen some pronouncements come out in the form of the pilot program, in the form of continued collaboration with other countries, increased resources, major cases, transparency. These are things that I think that are, if there's going to be a heightened enforcement of the FCPA, these are things that are useful to know, useful to have for the defense community, because the more we know as to what goes into the thinking of prosecutors or SEC attorneys in their decisions on enforcement against corporate America, it's very helpful as a defense attorney to know that in defending those companies.
Yeah, just one comment on the Yates memo. As you mentioned, the Yates memo is not necessarily FCPA specific, nor did it technically occur in 2016. It was September of 2015. And, I hate to always be the statistics guy, but there have been 13 corporate DOJ FCPA enforcement actions since the Yates memo was announced, and not one of them has involved related prosecution of individuals by the Department of Justice. So, again, it'll be interesting to, see what happens in that space. So thank you for joining us, Karen. It's been a very interesting year, 2016 in FCPA enforcement, policy developments, and here we are in 2017. Towards the end of the year in December, the FCPA turns 40, which is sort of a notable anniversary, so it'll be an interesting space to watch in this year as it has been in prior years. So thank you for joining us.
Well, thanks for having me. It's been a delight being here.